Indian Constitution is not just a mere document, but a living document. The Parliament has been given the power to amend the Constitution so that it can be relatable with the ever-changing world. But is such power to amend Constitution is absolute? Can Parliament change the whole Constitution and make a new one using amending power? Let's find the answers by the end of this video. In this video, we'll explore the key milestones in the evolution of the doctrine of basic structure and its timeline. But before going into that, it is important to know the following two articles of the Constitution: Article 13 and Article 368. Article 13 says that any law which violates the fundamental rights is void, whereas Article 368 gives the power and procedure to amend the Constitution. Now, the main issue is that does the word law includes amendment made by the Parliament? Can an amendment made by the Parliament which is in violation of the fundamental rights be declared void? The judiciary has tried answering these questions through many judicial precedents, a few of which we are going to discuss in this video. The zamindari system was prevalent in newly formed India. To abolish it, some states implemented measures to change agrarian policies. These enactments led to the redistribution of properties owned by wealthy zamindars in the country. Saddened by this, the zamindars in Shankari Prasad versus Union of India alleged that their fundamental right to property had been infringed and sought justice in courts of law. So many petitions regarding the violation of right to property by the state has been filed before the courts all over India. To tackle this problem and put an end to these suits, the Union Parliament has passed First Constitution Amendment Act, 1951. The First Amendment has restricted the right to property, consequently approving the zamindari abolition laws. Articles 31A and 31B have been included to the Constitution with retrospective effect so as to approve the actions of the states. Further, Schedule 9 was introduced in which all laws relating to land reforms are placed. Any law placed in Schedule 9 cannot be made void, even though they are violating the fundamental rights. The validity of the First Amendment has been questioned in Shankari Prasad case through a petition under Article 32 of the Constitution. The Supreme Court has ruled out that the legislature's power to amend the Constitution under Article 368 also includes the power to amend fundamental rights. It further held that there was a clear demarcation between ordinary law made in the exercise of legislative power and constitutional law made in the exercise of constituent power. Article 13 applies to ordinary laws, whereas the question law is an amendment act which is not an ordinary law. Therefore, Article 13 does not include constitutional amendments. Hence, the amendment is constitutionally valid though it takes away any of the fundamental rights. The decision of the bench was unanimous. In the case of Sajan Singh versus State of Rajasthan, 17th Constitutional Amendment Act was questioned. Under 17th Amendment Act, different state governments placed their land reform acts in Schedule 9, as Schedule 9 provides immunity to the laws being questioned by judiciary through judicial review. When a law is placed in Schedule 9, such law becomes valid though it violates the fundamental rights, and it cannot be questioned. Such law implements irrespective of its violation of fundamental rights. A 5-judges bench heard the case and held that the 17th Amendment Act is valid. The judgment has been passed with 3-2 majority. The minority judgment written by Justice Mudhoker and Justice Hidayatullah. Justice Mudhoker has stated that fundamental rights are not playthings. This case is followed by Golagnath versus State of Punjab, where 11 judges bench heard the case. In this case, the court with 6-5 majority held that the Parliament has no right to amend the fundamental rights. The majority was of the view that the cases of Sajan Singh and Shankari Prasad were erroneous decisions, and they gave precedence to the amending power of Parliament over fundamental rights. Fundamental rights cannot be abridged or taken away by way of amendments through Article 368. Although the definition of law in Article 13(3)(c) does not expressly mention amendments, in a wider sense is included in it. Hence, Parliament has no power to amend any provisions. This was a major landmark judgment that has laid down the foundation for protection of fundamental rights from amendments. However, the court has granted rigidity to the Constitution. The court said that if there has to be an amendment, then it has to be through a constituent assembly. To nullify the Gollock-Nath decision, the Parliament passed the 24th Amendment Act, 1971, wherein Parliament added Clause 4 in Article 13, which stated that nothing in Article 13 shall apply to any amendment of this Constitution made under Article 368. Further, it added Clause 3 to Article 368, which says that nothing in Article 13 shall apply to any amendment made under this article. Article 368 earlier contained the provision in which the procedure of amendment was given and not the power. Therefore, in order to include the word power in the article, Article 368 was amended and the word power was added in the marginal note. It also made it obligatory for the President to give his assent on all the Constitution amendment bills sent to him. The Parliament tried to draw a line between the procedure in an amendment and ordinary law through the amendment. Through 25th Constitutional Amendment, the property rights are restricted. The Parliament wanted to make it clear that they are not bound to adequately compensate the landlords in case their property is taken by the state government, and in order to do so, the word compensation was replaced with the word amount under Article 31, Clause 2 of the Constitution. 26th Constitutional Amendment abolished privy purse. Privy purse is a kind of social security or pension provided by the government to the princes of princely states which got merged with India after independence. Through 29th Constitutional Amendment, 9th Schedule has been expanded. This included regulations from Kerala that placed a strong emphasis on land reform. The Kerala Land Reforms Amendment Act 1969 and the Kerala Land Reforms Amendment Act 1971 were added to the list. The validity of these three amendments, that is 25th, 26th, and 29th constitutional amendments, was questioned in the most famous case of Keshavananda Bharati versus State of Kerala. Keshavananda Bharati is one of the most well-known cases and a landmark judgment which was 700 pages that included a solution for both Parliament's right to amend laws and citizens' right to protect their fundamental rights. The bench came up with the doctrine of basic structure in order to protect the interests of both citizens of India and the Parliament. A 13-judges bench was constituted, with an overwhelming majority of 7 judges out of 13 ruled in favor, upholding the legitimacy of 29th Constitutional Amendment. The court opined that the wide powers of the Parliament under Article 368 of the Indian Constitution were subjected to the basic structure doctrine. Any component forming part of the basic structure was not open to amendment by the legislature. The significance of the Keshavananda Bharati case lies in the fact that it established the doctrine of basic structure of the Indian Constitution. The basic structure doctrine holds that certain fundamental features of the Constitution, such as the supremacy of the Constitution, the rule of law, and the independence of the judiciary, cannot be amended or abrogated by the Parliament through a constitutional amendment. Justice S.M. Sikri stated that the true position is that every provision of the Constitution can be amended provided in the result the basic foundation and structure of the Constitution remains the same. The basic structure may be said to consist of the following features: supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers between the legislature, the executive, and the judiciary, federal character of the Constitution. The above structure is built on the basic foundation, that is the dignity and freedom of the individual. This is of supreme importance. This cannot by any form of amendment be destroyed. He further stated that this is not an exhaustive list. Additions can be made in future to the list. On June 12, 1975, Allahabad High Court quashes Indira Gandhi's election because of electoral malpractice. It further disbarred Indira Gandhi from holding any electoral officer for a period of 6 years. Unsatisfied with the decision, she files an appeal to SC. However, one day before hearing of the appeal, Indira Gandhi passes 39th Constitutional Amendment Act. After a few days from this incident, she announces national emergency. 39th Amendment Act introduced Article 329A, which says that the Supreme Court does not have power to try electoral disputes of President, Vice President, Prime Minister, and Speaker of Lok Sabha. A separate body will be constituted to try those disputes. In addition, the amendment also removed Article 71 from the Constitution. The Supreme Court was not able to try the case of Indira Gandhi after this constitutional amendment. The objective of the amendment was very clear, that Indira Gandhi wanted to continue as Prime Minister and hence passed an amendment to nullify the judgment of the court. However, people selects Morarji Desai as their new Prime Minister in the elections. After coming into the power, the Janata Party undo all wrongdoings done during emergency by passing laws. It also repeals Article 329A and brings back Article 71. As we all know, 42nd Constitutional Amendment is called Mini-Constitution. It has made many changes to the Constitution, which also included addition of Article 13C along with addition of Clause 4 and Clause 5 to Article 368. Clause 4 of Article 368 says that Parliament has power to amend Part 3 of the Constitution, and it cannot be challenged before a court. This reduces the scope of judicial review. Clause 5 says that the amending power of Parliament does not have any limitation. This clause is added to nullify the impact of the Keshavananda Bharti judgment. The amendment further included a provision that states that if a parliament adds any provision to Part 4 of the Constitution, then it is valid though it violates fundamental rights. In the case of Minerva Mills, the government acquires Minerva Mills in the name of nationalization. Supreme Court held Article 13C, Article 368 Clause 4 and 5 invalid, and added 3 more basic features to the list. First, judicial review. It cannot be surpassed by the Parliament. Second, limited amending power of Parliament. The Parliament cannot expand its power using the limited power conferred on it. It is not an absolute power. Third, harmony between Part 3 and Part 4 of the Constitution. There should be a balance between fundamental rights and DPSB. After basic structure doctrine has been introduced, all amendment acts were questioned and challenged based on the doctrine. Keshavananda Bharti judgment was pronounced on April 24, 1973. Therefore, the amendments made after April 14, 1973 can be questioned based on test of basic structure, but not the amendments made before that. It applies prospectively and not retrospectively.